There are 3 things you should never do during a deposition. You want to know what they are? Come join me as I share with you the answers to those questions. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. All right, so let's say you brought a lawsuit against your doctor who's careless, causing you significant harm and injury. Now, during the course of your lawsuit, you will be questioned by the attorney who represents the doctor whom you have sued. This is known as a deposition. We also call it an examination before trial. You will be asked questions about what happened, what problems you had, and importantly, what problems you have now. One of the things that you have to pay close attention to when the attorney is asking you questions, the opposing attorney, is that when he asks you a question about things that led up to the malpractice, the number one thing you have to do is to answer only the question that is asked. This is not your opportunity to go ahead and tell him every single thing that happened. This is not your opportunity to go ahead and tell him every specific tiny detail that really has nothing to do with the claims of malpractice. Listen very carefully to the question that you are asked. Answer no more than what you are asked for. Number 2, the second thing you should pay very careful attention to is that when it comes time to your injuries, to discussing the problems that you have, the attorney will ask you very specific questions by asking you, hey, what problems do you have now? That is not an opportunity for you to turn around and say, you know what, this happened 2 years ago, I'm kind of fine now. Because if you do that, what you have now done is you have limited the extent of your damages. You have limited the injuries because the attorney wants to know by that question, how are you doing now? How are you feeling? He doesn't want to hear a general answer that says, oh, I'm fine. No, he wants to hear specifically, what problems do you have today that you didn't have before? What problems do you have going forward, or what limitations or disabilities do you have today that you didn't have before? How are you limited in doing your everyday daily activities? That's what he wants to know about. Plus, he'll ask you questions about your medical care and treatment. The third thing you have to be careful about is the attorney will ask you whether any doctor has criticized the care that you received. He wants to know whether any doctor you've treated with has told you that the care and treatment that you received was improper, causing you harm and injury. Why is that? Because he wants to know if anyone supports your claim. He wants to know if anyone who's treated you supports that claim. Plus, if they do, he will now ask us for permission slips to go ahead and try and talk to that doctor to learn more details about exactly what it is that this doctor said, exactly why he said that, and what he thinks, what he really thinks about your injuries. So why do I share this quick information with you? I share it with you just to give you a sense of what really happens in these medical malpractice cases in New York. You know, I recognize you're likely watching this because you have questions or concerns about your own matter. Well, if your matter did happen in New York and you have not yet started a lawsuit but are thinking of doing so, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.